Hi, I'm Alan Beaver. Welcome to this episode of Understanding Tort Law, the Law of Private Nuisance. In this episode, we're going to look at three cases that deal with the question, does the defendant's motive matter? Now, as we're going to see, there are two sides to this argument. There are people who think that the defendant's motive can't matter, and there are people who think that the defendant's motive can make all the difference as to whether the defendant is going to be liable or not. What I'm going to try and convince you of is that neither of these two sides are right. In fact, the truth lies somewhere in the middle. The defendant's motive can matter, but not quite in the way that people often think that it matters. So our first case is the very famous decision of the House of Lords in Mayor of Bradford and Pickles. So what's happening in this case is that there is an underground river that flows under the defendant's land and into the plaintiff's, and it fills up the plaintiff's reservoir, the plaintiff being the Mayor of Bradford. And this is very important for the plaintiff because they use this water to supply water to the town, the town of Bradford. Now, there's been some ongoing dispute between the parties, and were this relevant, I would spend more time going into this dispute because it's a very interesting dispute between the parties and it's really worth digging into if you're interested in the history of the case. But for the moment, let's just put all that aside. Let's just say there's an ongoing dispute between the parties, and the effect of this dispute is that the defendant wants the plaintiffs to pay for the water. They want him to give him some money towards the water, and the plaintiffs are not interested in doing this. They say, look, we're getting this water for free now, we don't want to pay you. No, we're not going to come to the party. So what the defendant does is he sinks some shafts down into his own property, the result of which is that the water in the river gets redirected and significantly less water flows down into the plaintiff's reservoir. Okay, now the plaintiffs aren't very happy about this because now they've got less water than they had before, and they sue the defendant in nuisance. Their claim is that the defendant in this case is motivated by malice. He's not damming the water to use, that is, the defendant is not damming the water to use it himself. He dug these shafts into his land solely in order to prevent the water from going into the plaintiff's reservoir, so that he could negotiate with them about money and so on. So they say he's motivated by malice, and so therefore the court ought to find in favour of the plaintiffs. Now, the court doesn't find in favour of the plaintiffs, the court finds in favour of the defendant. And we need to spend some time considering why. The most famous judgment in the case is that of Lord Watson. I think it's the most famous because it's probably the most easy to understand. And in any case, whether that's true or not, this is what Lord Watson has to say. He says, "No use of property which would be illegal if due to a proper motive can become illegal because it is prompted by a motive which is improper or even malicious." And we can summarise this argument by saying, as I have below, if the act is lawful, then the defendant has a right to do it. If the act is unlawful, then the defendant has no right to do it, and therefore it must follow from this that malice is irrelevant. Now, if many textbooks, many commentators on this case will tell you that this is what the case stands for. What this case stands for is the view that the defendant's motive is irrelevant. And indeed, I can't really criticise people that much because I used to hold this view too. But there are a couple of things that we should notice about Lord Watson's judgment. The first is that Lord Watson doesn't provide any reasons for his view. So, he says that malice can't be relevant, but he doesn't explain why it can't be relevant. He just says it. The other thing is that the other judges in the case don't accept Lord Watson's view. They don't reject it, but they don't accept Lord Watson's view either. They find for the defendant for different reasons. And that's important because if it's only one judge in the case supporting the view that malice can't be irrelevant, that the motive can't matter, then we ought to be more careful about saying that view is what this case stands for. The other thing is to note that the argument, that my sort of summary of Lord Watson's position, that argument is a very bad argument. Remember, the argument that goes, if the act is lawful, then the defendant has a right to do it. If the act is unlawful, then the defendant has no right to do it. Therefore, malice is not relevant. That's a very bad argument because it assumes what is at issue. What is at issue here is whether the motive of the defendant, whether the malice can make any difference. And the argument simply assumes that it can't, because it says if the act is lawful. Well, maybe the malice determines whether the act was lawful, right? So it's certainly true that if the act is lawful, then the defendant had a right to do it. If the act is unlawful, then the defendant had no right to do it. Of course that's correct. But the issue is whether malice can have a role in determining whether the act is lawful or unlawful. And the argument doesn't really pay any attention to that possibility at all. It simply assumes that it can't. It's also the case, it seems to me, although we won't be able to discuss this here, that in other areas of law, particularly in the economic torts, but also in the intentional torts, which we'll talk about at a later date, it's pretty clear that the defendant's motive, in a certain sense of the term motive, certainly if we mean intention, can make all the difference between whether the defendant is liable or not. So I think the general proposition that the defendant's motive can make no difference is wrong. At the very least, it's too broad. Now, a completely different argument for the defendant, for finding for the defendant, can be seen in Lord Halsbury's judgment in the extract that I've given you. For Lord Halsbury, the situation is very simple. Basically, the problem with the plaintiff's claim is that the plaintiff never had any right to the water. So the plaintiff's complaint is, look, if the defendant hadn't performed this activity, if he hadn't sunk shafts into his own land and diverted the water, we would have got this water into our reservoir. And Lord Halsbury's response to this is to say, yeah, but you never had any right to that water. At least until you collected it in your reservoir, you never had any right to it. This is water that perhaps, the water that you're complaining of not getting, is perhaps water that you would have gained a right to had the defendant not acted, but it is not water that you ever had any right to. So the complaint is not that the defendant has taken some of your water, right, but that he has diverted the river so that you don't get the water. So the plaintiff is not complaining about the loss of something to which the plaintiff ever had a right. The plaintiff is complaining about the loss of something over which they had no rights at all. So Lord Halsbury says there has been no violation of the plaintiff's rights here, and because of this, there can be no legal wrong. They're complaining about the loss of water that they had never had any entitlement to receive. So, and what Lord Halsbury is saying is that in such circumstances, the defendant's motive is irrelevant. What are the circumstances? Circumstances in which there's been no violation of the plaintiff's rights. If the defendant has not violated the plaintiff's rights, then the defendant's motive is irrelevant. But it might be the case that sometimes the defendant's motive will be relevant in determining whether there has been a rights violation. That's a separate question. In this case, it's clear, says the court, that the plaintiff never had any right to the water in question. They never had any right to receive the water. Therefore, the defendant never violated any right that the plaintiff had, and so therefore, no wrong. We don't even get into the question of whether the defendant's motive might be significant. That's Pickles. So our next two cases are going to be discussed together because they raise very similar issues and are most usefully discussed in conjunction. Hollywood, Silver Fox Farm and Emmett, and Christie and Davey. So in the Hollywood case, we have two neighbours who obviously hate each other. There's been a dispute about a sign that's been placed on. Anyway, we don't need to worry about this. The fact is, they're not getting on. Now, the plaintiff has a fox farm. The plaintiff is raising on his farm silver foxes, which are peculiar animals for reasons that we'll see in a second. And the defendant has a farm. And the defendant, or actually the defendant's son, but that doesn't matter, the defendant is firing guns on his property. He says to the court that he's doing this in order to control rabbits. So he's killing rabbits to control rabbits on his farm. But the evidence is pretty clear that that's not why he's doing it. He's doing it because he's trying to damage the plaintiff. He's basically, as we might say, blackmailing the plaintiff. He's saying, I'm going to shoot these guns. I'll stop if you remove the sign, but if you don't, I'm going to keep firing these guns. And the effect that these guns have on the plaintiff's foxes is rather extraordinary. The noise stops the foxes from mating. It causes the female foxes to miscarry when they're pregnant, and even to attack and kill and eat their young when they have them. So obviously this is a pretty serious problem for the plaintiff. This is destroying his business, and he wants the firing of the guns to stop. And so he takes the defendant to court and sues for nuisance. Okay, so that's Hollywood. Now the other case is Christie and Davey. The plaintiff in this case is a music teacher who gives lessons on her property, and the defendant is her neighbour. They share a party wall. There's a wall between their houses, and the neighbour, the defendant, hates the noise, and he responds to hearing this music by banging on the walls with pots and pans and so on. Right, and obviously the plaintiff is not happy about that and sues the defendant for nuisance. Now, the way that the defendant presents his argument in court has had a huge impact on how this case has been interpreted. For instance, the defendant says to the court, "I have a perfect right to amuse myself on any musical instrument I may choose. What I do is simply for recreation's sake and to perfect myself in my musical studies. You say that I interfere with your client's professional pursuits. Just so. This is simply reversing my complaint, and what is sauce for the goose is sauce for the gander." So what the defendant is saying here is look, the plaintiff is complaining about what I'm doing, but what I'm doing is just the same as what the plaintiff is doing. So, what's good for the goose is good for the gander, right? The plaintiff isn't entitled to sue me for doing what I'm doing when I'm just doing what the plaintiff is doing, right? So basically the claim is the parties are, in this case, the plaintiff and the defendant in Christie and Davey, are involved in the same activity. And because of this, it can't be the case that the defendant alone is committing a nuisance. They're either both committing a nuisance or nobody is committing a nuisance. Now, this is how this case is normally interpreted, and we can see a summary of this in this slide. Most interpretations of Christie and Davey interpret the case this way. In Christie and Davey, the defendant was making noise, the plaintiff was making noise. This is the same activity. Now, the court finds for the plaintiff. Why could that be? Well, it must be because of the defendant's malice. The defendant's malice, as it were, breaks the tie between the plaintiff and the defendant. Right? Because the plaintiff was not malicious, because the defendant was malicious, the defendant and not the plaintiff is committing a nuisance. Now, things are slightly more complicated in Hollywood, but it's the same basic idea. Right? Here again, as usually interpreted, in Hollywood, the defendant was shooting, the plaintiff was raising foxes. On the face of it, the defendant's activity was more ordinary, reasonable, fundamental, whatever term you want to use, than the plaintiff's in the England of the day. So on the face of it, it looks as if the defendant should win, but the court actually finds for the plaintiff. Thus, it must be the case that malice reverses what would otherwise have been the outcome of the case. So on the standard interpretations, on the interpretations you're likely to find in textbooks, what you'll find people saying is that the defendant's malice made the difference in these cases. In Christie and Davey, it would have been a tie, but the defendant's malice meant that the plaintiff won. In Hollywood, the defendant would have won, except that his malice reversed that result. Okay, now, that's, as I say, the standard view. It's not my view. I think the standard view is wrong. I think the standard view is actually bizarre. And let me engage in a little experiment to reveal this. Tana, what are you doing?
I'm making noise.
Petty, what are you doing?
Doing the same thing as Tana.
Now, no parent would fall for this. It's clear that my sons are not performing the same activity. They are performing different activities. And it strikes me as a remarkable thing that commentators for 100 years or so have been fooled by the defendants' argument in Christie and Davey. The court wasn't fooled, I don't believe. The court wasn't fooled. But commentators, academic commentators on Christie and Davey have been fooled for all this time by the defendants' arguments into thinking that really the right way of regarding these cases is that the parties were involved in the same activity. Totally implausible. Now, one of the things that this goes to show is the power, the incredible power that the parties and counsel for the parties have in framing their description of the dispute. It's extremely important. And in that light, it's worth taking a minute to pause and think about how this works. Okay, so let me just do something. I have a pen in my hand and I'm going to drop it. Okay, now the question is, what did I just do? Now, it's a very simple thing that I just did, but what was it? Well, here are some answers. First of all, I moved my fingers. Second, I made a noise. Third, I utilized gravity. Fourth, I dropped the pen. Fifth, I taught you something about the law of nuisance, or at least that's what I hope. Now, the point I want to make about this is that those descriptions that I gave of my activity are all different, but they're all true. Each of those descriptions is true. Now, nevertheless, you would have found some of those descriptions odd. So when I drop the pen, if someone asks you, what did Alan just do? And you just said, oh, he just moved his fingers. That would be a very odd way of describing what I did. It's nevertheless true, right? But it's strange. Similarly, if someone were to ask you, what did Alan do? And you replied, he utilized gravity. Right, that would be a very odd thing to say, but it's nevertheless true. Now, the key thing to see here is that when we're describing events of this kind, what's important is not just to come up with descriptions that are true, but to come up with descriptions that are appropriate. Truth isn't enough here. We need to come up with descriptions that are appropriate. Now, what's appropriate will depend on the context. So in this context of delivering a lecture on the law of private nuisance, saying that I did this, one of the things that I was doing was teaching you something about the law of nuisance, that is an appropriate description of what I was doing. But if this were not an episode on the law of private nuisance, but the law of the history of physics, where we were discussing Isaac Newton, that wouldn't be an appropriate thing to say. Perhaps in that context, saying I was utilizing gravity would be an appropriate thing to say. Okay, so what counts as appropriate depends on the context, and that's the same in these cases too. There are many ways, in these nuisance cases, and in all cases in law, but particularly in these nuisance cases, there are many ways in which we could describe the activity of the parties. There are an infinite number of ways in which we could describe the activity of the parties. What we need to do is not just describe the activities of the parties truthfully, we need to describe them appropriately. So it's quite true that in Christie and Davey, for example, both parties were making noise. That's absolutely true. But the question is not whether it is true. The question is whether that is an appropriate description of the way the parties were behaving. And I think our experiment revealed that it's a totally inappropriate way of describing how the parties were behaving. A more appropriate description of how the parties were behaving might look like this. So in Christie and Davey, we might say the defendant was banging on the walls, the plaintiff was playing music. Now, if we interpret the case this way, then the plaintiff's activity was more ordinary, reasonable, or fundamental, or whatever you prefer, than the defendant's. The plaintiff wins. In Hollywood, what was the defendant doing? The defendant was damaging the plaintiff's property. The plaintiff was raising foxes. The plaintiff's activity was more ordinary, reasonable, or fundamental than the defendant's, and so the plaintiff wins. So on these interpretations, it's not that the defendant's motive reverses what would otherwise have been the decision of the court. It's not that the defendant's motive breaks a tie. It's that you take the defendant's motive into account when you interpret the activity that the defendant is performing. And this is an ordinary feature of understanding human behaviour. There's nothing strange about it, though unfortunately lawyers are sometimes inclined to think that there's something strange here. When we interpret human behaviour, when we ask what was that person doing, we always take into account their intention or what we think their intention is. So when I dropped my pen, the reason that you say, that's an intentional action, right? Dropping a pen. You say, I dropped it because you assumed that I intended to drop it. That's a reference to my motive. I'm teaching you something about the law of private nuisance only if that's my intention, right? If I'm just randomly saying I'm trying to write poetry or something, then it wouldn't be true, right? That I was trying to teach you something about the law of negligence. We identify the defendant's activity in part by paying attention to the defendant's intention, and that is a reference, a limited reference to the defendant's motive. Okay, now, so it can't be the case that we ignore motivation entirely, because in order to know what the defendant was doing, in order to know what the plaintiff was doing, we need to look at the parties' intentions. Now, as I say, there's a whole list, there's an infinite number of interpretations that we could give of the parties' behaviour in these cases, in any cases. What we have to do is to adopt the most appropriate intention. Now, the key thing to say here, our key thing to say here, is that there is no rule for determining what is the most appropriate intention. There is no formula that we can apply to determining this. This requires judgment, as so much else does in law. You simply have to ask yourself, what is the most appropriate interpretation of the parties' activities available? It will be one that accurately describes the dispute that the parties are having. The appropriate interpretation of the parties' activities will be one that captures their dispute properly. So the question is, who in Christie and Davey would have said what the parties are arguing about is that they're both making noise? That's not what the plaintiff's complaining about. The plaintiff is not complaining about noise. The plaintiff is complaining about the defendant banging on the walls. That's what she's complaining about. It's not just about noise in the abstract. It's about banging on the walls. Right? That's relevant to the dispute. In Hollywood case, what is the plaintiff complaining about? It's not simply the firing of guns. It's the firing of guns in the circumstances in which the guns have been fired. That is, they've been fired in order to cause property damage to the plaintiff. You see, if the defendant in that case had been trying to control rabbits, then the defendant probably would, almost certainly would have won, because the defendant in that case would have been able to say, hey, I'm just trying to preserve my own property from being destroyed by rabbits. But that's not what the defendant was actually doing in that case. So we need to adopt the most appropriate interpretation of the parties' activities. There's no formula for determining that. It requires judgment. Sometimes reasonable people will disagree about the appropriate judgment, but it's not a free-for-all. In most cases, there will be widespread agreement on the appropriate description of the parties' activities. Although, as we see, in these two cases, something seems to have gone haywire, not in the courts, but in the way that academics have interpreted these cases. So the question, does motive matter? The answer is yes, it matters. But it doesn't matter in the way that people think it matters. It doesn't reverse decisions. It doesn't break ties. It matters because we need to use it when we interpret the activities that the parties are engaged in. Thanks very much. If you liked this video, please hit like. And if it was useful to you, please hit subscribe so that you can be made aware of future videos. Thanks very much.